This video may contain what could be considered attorney advertising under the rules of your state. This video is for information purposes only and should not be construed as legal advice. If you have a legal problem, it's vital for you to seek out and talk to a licensed attorney for advice. Good morning, good evening, and good afternoon, wherever you may be. My name is Chris Simmons, attorney at law, and today we're going to discuss family-based immigration, particularly visa bulletins. Family-based immigration takes a long time depending where you're immigrating from. In fact, it takes so long that we have bulletins to explain at what point they're processing applications. So to get to this page, the simplest way is simply search for Visa Bulletin, but it's with the State Department, travel.state.gov, and then look for Visa Bulletin. So we're going to go into this. They publish these monthly. The current one is December 2017. And if we click on this, we'll get to this. Now, there's a couple of things we need to explain. First, what are all these categories? Second, what's a minor child for immigration purposes? Third, how many people get in? And fourth, how do you actually read the chart? So, the first is easy. What is the categories? Well, if you read right here, it's very simple. First category, F1, it's unmarried sons and daughters of U.S. citizens. These are any sons and daughters of U.S. citizens. Only 23,400 can be accepted unless there's unused fourth preference, F4, at which point those numbers are added to the F1. Second, spouses and children. And a child is anyone who is under the age of 21. Unlike normally, when we think of a minor child, we think of someone who's under the age of 18. For immigration purposes, if you are 21 years of age or younger, you are considered a minor child. So, for F2, there are two types, F2A and F2B. F2A, spouses and children of permanent residents. What's permanent residence? A permanent resident is simply someone who has their green card. I will be referencing them as LPR, lawful permanent resident. F2B is unmarried sons and daughters, 21 age or older of permanent residents. These 114,200 plus any number that exceeds 226,000 for a preference level. 77% of them must be F2A, 23% must be F2B. Simple. Third preference, married sons and daughters of U.S. citizens, USC for short, 23,400. Now these are married. There's the distinction. Immigration makes a distinction between married and unmarried. It also makes a distinction between child and adult. Again, 21 years and older is an adult. 20 younger than 21, you're a child. For purposes of marriage and unmarried, married and unmarried, for children, a child who is married and then gets a divorce before 21 would be considered unmarried. Finally, you have fourth preference. These are the people that get picked last. These are the brothers and sisters of USCs. Notice that almost all of these require the person petitioning to be a U.S. citizen. And that's how this works, is the U.S. citizen or the lawful permanent resident in the case of second preference, must petition for the family member. So the U.S. citizen must petition for the son or daughter. The U.S. citizen must petition for the brother or sister. The permanent resident must petition for the spouse and child. The immigrants do not petition themselves. It's the sponsors who do. So we've covered all of that. Finally, I said that it takes a long time, and if you look down here, we can see this. The chart is based categorically in the rows and by where you're from in the columns. All chargeability areas except those listed. That means everywhere except for mainland China, India, Mexico, and the Philippines. If you are from any of those, you will have a different date, as is right here. Now here's how you read this. These are the petitions that were filed at this time. So this may seem complicated, it's really not. If you were to petition for your brother or sister, and you're a U.S. citizen, so they would be an F4. Your brother or sister would be an F4. And your brother and sister is from India, for instance. Well, you would look down, F4. They are currently processing applications from the 22nd of November, 2003. That means there is a 2017 minus 2003, a 14-year lag in the processing, which means your brother and sister would most likely have to wait 14 years before they're ever eligible, before their application is ever properly processed, and that process can actually start. We can look at these for F1s. They're lagging behind 6 years, February 1st, 2011. Philippines, generally the longest in some of these. Mexico is really long in some of these as well. For F4, the Philippines are the longest. They are backed up all the way to the 1st of August, 1994. They've only now gotten to those applications. For Mexico, 22nd of May, 1995. They've only now gotten to those applications. Now, there are other ways of getting into the United States through immigrant petitions. These are, and these are on the same page, employment-based. The C here means current, which means all of these are currently being processed. There's no wait time. Except for China, in the second, third, another worker, and a couple of others, and you can read these here, or we'll go over them later. And then you have the diversity visa, which is also on the same chart, and you can read that. We'll go over it in another video. But in a nutshell, that's how you do immigrant-based visas, family sponsored. You can always check to see what applications are being processed at this time by simply knowing where your family member is from, when you filed the petition, and knowing which specific preference they're in. So, it seems more complicated than it is. It's really not. Hope you've learned something. We'll see you in the next video.